like to welcome everybody for our 4Gen Now webinar. Today we are very, very excited to have Ben Oelsner. Ben is one of the founders of KO Firm and presently is a partner at KO Firm. And today's webinar that Ben will be leading is Intellectual Property Ownership for Entrepreneurs. Ben, thank you very, very much for your time. Thank you for your support of 4Gen Now. And with that, I gladly pass the baton over to you.
Thank you, Jim, and thanks for everybody for joining and coming to this webinar and checking it out. I'm gonna just kind of start the slide presentation, go through a few things. This is a webinar about intellectual property for entrepreneurs. A little bit of background on what KO is. We're a select team of business lawyers. We were founded in 2003, and we basically perform two kinds of legal services for people. We do corporate formation, financing, and M&A transactions, and we also do commercial and intellectual property transactions. A little bit about me. I have 20 years of experience working with startups and growth companies. I basically, create, structure, and draft all kinds of intellectual property agreements and other commercial contracts. I really try to give practical legal advice, and the goal is always really just to help people get deals done and not to get in the way of whatever the transaction is. The advice I give most people is in connection with a deal. I try to really just identify the risks for them so they can make the decisions that they want to make for their company. Been a Techstars mentor since 2007. KO was a founding sponsor back when Techstars first started. We have offices in Denver and Boulder. I'm in the Boulder office. And my past history is I worked at two national law firms, Robeck, Flager, and Harrison in Palo Alto when I first started back in the 90s, and then Cooley Godward, which is Cooley now in Colorado when I moved out here in 1999. So this is just a disclaimer that I'm not your lawyer. I'm not giving you legal advice. So these are all my opinions about this. It is really just mumbo jumbo, so you don't have to pay too much attention to it. So today I'm going to basically kind of do an intro about intellectual property and why ownership is important. Intellectual property is one of the most important assets of any company, and care needs to be taken, especially when companies are first starting, to make sure that the company actually owns all of its intellectual property. If you pay attention to IP ownership early on, it's a lot easier to make sure that your company will own its intellectual property, and it's a lot harder and more expensive to try to fix intellectual property issues down the road. So usually when we first meet companies and we talk to them, there's two things that they can get wrong right away, and one of those is equity ownership in the company. They can mess that up. The other one is IP ownership, and so one of my goals with talking to anybody initially is to make sure that they understand what IP is and the ways that they can make sure that they own it and protect it. So what is intellectual property? So intellectual property is essentially property rights that have been given under law for certain types of things. So it's usually broken down into kind of four buckets, right? Patents, which are ideas and inventions. Copyrightable works, which are expressions of ideas. Trademarks, which are basically things that identify and distinguish goods and services. And then trade secrets, which are your confidential information and other kind of know-how that a company will create, in the course of their evolution. So one thing to know about intellectual property is that the rights that you have in IP are exclusive rights. And what that means is that it gives you the right to exclude other people from doing certain things that are the subject of that intellectual property. So you're given certain rights, and you're allowed to prevent people from exercising those rights. They're exclusive to you. And that's important because owning intellectual property isn't really a right to do anything. It's really just a right to keep other people from doing things, right? And that just keep that in mind when IP is being created, because you can create some IP and you might come up with an invention that you patent, but some other patent may actually stop you from exercising your rights to that. Okay, so I'm going to go through these kind of buckets pretty quickly. If you need to, you can go back and review these. But essentially, a patent is basically it's a monopoly granted by the government in certain types of inventions, essentially. And any patent, in order for an invention to be patentable, it has to be new, not obvious, and there needs to be some sort of industrial applicability. For copyrights, essentially are works of authorship, and the exclusive rights for a work of authorship are the right to keep people from reproducing the work, adapting it, which is modifying or creating derivative works, distributing it to the public, performing it in public, or displaying it in public. Copyright rights exist from the moment that you actually create the work. You don't actually have to file a registration, unlike the patents. The copyright law protects it right when you create it. It doesn't cover ideas. Copyright law doesn't cover ideas, which is what patents cover. And it doesn't cover information, which is data. So those two things are not protected by copyright law. It's really just the expression of the idea. And an example of that, a common piece of intellectual property that's copyrightable or protected by copyright law for my clients is software. Let's see, and there needs to be some minimal originality or creativity, and that's actually why data is really not protected by copyright law. It's protected but under other types of IP protection. Trademarks are essentially your brand identity that a company will build up over time. You get these rights essentially from using a trademark in connection with the sale of goods or service in commerce. The exclusive rights essentially are to what you can do is prevent people from using the same or similar mark in connection with the same or similar goods and services. So it's a likelihood of confusion test, and it's pretty complicated. I'm not going to go into it here, but just know that if you've ever kind of tried to clear a trademark, what you need to know is that you really don't want to pick a mark that somebody else is already using or that's similar to what somebody else is using in some similar kind of business, essentially. Trade secrets are a very broad category, and it's essentially business information that has value because it's not generally known. In order to create trade secret protection, you actually have to use reasonable measures to maintain secrecy. This is the main reason why you should enter into NDAs or other confidentiality type of agreements with anybody you're going to be disclosing your confidential information to. One of the differences between trade secret law is that it's actually state law based, unlike the other three types, which are all federal laws that protect it. And there's certain reasons why that matters. If there's a violation of a trade secret and you're going to sue somebody, you would do that in state court. If there's some infringement on some of the other rights, you would do that in federal court. Okay, intellectual property ownership. Who owns the IP that is created? Why is that important? How is ownership obtained? And I'll talk a little bit about control versus ownership, because there are instances where you actually may not be able to own the IP itself, but you still want to use it. So who owns the IP? Generally, the creator of the intellectual property is the owner, and the creator is the person, not the company necessarily. Company wants to own the IP. The creators of the IP are usually employees or independent contractors, which can be non-employees essentially or other businesses. And then I'll talk a little bit about founders and the kind of special case with founders, because they're not either one of these necessarily because of the nature of what they do, founding the company. So one thing you should know is that your company won't necessarily own the intellectual property that has been developed for the company. Just because you paid for the development and it was created for you doesn't mean that you actually own it. So what that means is that you have to do certain things contractually to make sure that you do own it. And what you have to do will depend on what type of intellectual property it is and who created it. So the basic rule for ownership of intellectual property created by employees is that the company will own the IP for the most part. With patents, the individual people are the inventors, but who they work for, the company, the employer will have rights to that patent. If you really want to, if the company needs to own it, they need to assign it over, right? So the best practice for any company who has anybody creating intellectual property for them that works for them is to have an agreement in place with every employee that essentially says that all of the intellectual property created by that employee is assigned over to the company. It's a little bit of belt and suspenders, but there are good reasons to do it. You may have heard of a type of agreement called the Proprietary Information and Inventions Agreement. This is something that every employee should sign, including the founders. It includes IP assignment provisions in it, but it also has some other things like confidentiality provisions and some other provisions that are basically beneficial for the company to help them make sure that their employees are bound by certain terms that they're going to need to be subject to over the course of their employment. One thing to note here is that one of the reasons that a company will own IP if it's copyrightable, which is a copyrightable work, is because an exception to the rule generally that the creator of the intellectual property is the owner is a concept called work made for hire, and I'm sure everybody's heard of this term. It gets used in a number of different ways, probably incorrectly a lot, but essentially, when a copyrightable work is created by an employee as part of the employee's regular duties, that is a work made for hire, and that work is owned by the company as quote unquote the author. So there's no assignment necessary. But if they're not an employee, then it can still be a work made for hire, but it has to fall into some very specific categories that generally, for most of my clients, that's not going to happen, right? So if it, like, for example, if an independent contractor creates some intellectual property, then that independent contractor is actually going to be the owner of that intellectual property. And then what they need to do is really assign it over to your company or whoever is paying them to develop it. So independent contractors are essentially non-employees or businesses, either individuals or businesses. They can include consultants, developers, temporary non-employees, any kind of service provider, and just basically think of as an independent contractor. When they create intellectual property for you, even if it's under a contract, the company's not going to be the owner unless there's a written agreement in place that actually says that they're signing over the intellectual property that they're creating. That's really important to know because you have these, what I'll call magic words especially for copyrightable works. If there isn't language that says I hereby assign whatever the work is, then the company isn't going to own it. And so if you say something like the company's going to own, or the company owns the IP or the work, that isn't sufficient under the copyright law. So you have to enter into written agreements that say that the IP rights are assigned over, and there is, for work made for hire, even though this gets used a lot in independent contractor agreements, there's a very limited subset of different types of copyrightable works that are works made for hire. An example would be if you were hiring somebody to write a book or write a chapter in a book that you were creating, you had multiple independent contractors. That's something that you could agree in a contract that's a work made for hire, but almost anything else is not going to be. So for example, if you hire a contractor or to develop software for you, that's very unlikely that it would fall within one of these categories. And what that means is it's not going to be a work made for hire even if you agree in a contract that it is. And so you have to have that assignment language also. Now you'll see contracts that do both. I'm not going to get into the pros and cons of doing that, but generally, just so you know, saying something is a work for hire doesn't necessarily make it so, and therefore you really want assignment language in these types of contracts. So let me talk a little bit about founders. Founders are unique because they're usually creating intellectual property before the company is actually created, right? So typically what happens when people get together and they found a company, they may have created intellectual property and they will assign that over using basically a simple technology assignment agreement. And what they usually get in exchange for that is the equity in the company. So you have to be careful when you're a founder, because if you work for somebody else, then you have to make sure that you're creating intellectual property separate from whoever your current employer is, because there could be ownership issues in connection with that employer-employee relationship with that other company. And so it's very important to kind of keep things separate if you're going to found a company and start to create intellectual property, because you don't want your current employer or your former employer to come back and say that they actually own it. So so think of a timeline as everything before the company is founded. You'll do like a technology assignment agreement. Everything that's created by the founders after, they should just be employees, and so they should sign a proprietary information and inventions agreement where everything they do after the company is founded, the intellectual property gets assigned over to the company. So why am I talking about all this stuff? Like, why is this important? There are a number of things that can happen, bad things that can happen to a company if they don't own their IP, right? If you don't own the IP that you have, you may be prevented from carrying out your business, and you can get involved in litigation because you may be using IP that you don't own, and so somebody can initiate an infringement suit against you. Another reason is that if you're a company that's going to be getting funded, and investors are going to look at your company and do due diligence on it. And if you're going to have investors and you're going to have some sort of exit, and so an acquirer of your company will do due diligence too. They will expect that you have all of the ownership rights to the intellectual property that you're using in connection with your business. The things that you don't own, you should have a license to, but they're going to want to make sure that you have the rights to the things that you basically say that you own. And so you'll have to make reps and warranties in a financing agreement or an acquisition type of agreement. And then just, basically not having rights, there's the lawsuits regarding IP create a bunch of problems for the company. It can mean that you may not get funded. It can take a lot of time away from operating the business. It can be very expensive. So there are a lot of reasons to make sure that from the very beginning of the company, or as early on as you can, make sure that the company is going to own all the IP. So some of the most common direct consequences of not owning your IP is that you could find out that somebody makes a claim against you. Let's say you hire an independent contractor, you didn't get an assignment, and then you find out that you don't own the IP, and then they basically kind of hold you for ransom, basically saying, if you want to use this, you got to pay me more money. I think one of the most common areas I see in this is when companies will hire a marketing person, an independent contractor like a marketing company. And there's nothing in that agreement with the marketing company when they're creating content for the company that says that the marketing company is assigning over all the rights to whatever they're creating. And so if you want to use that, that content later on yourself or do certain things with it, you may not be able to because you don't own it. And you have to go to the company and they may say, no, I'm not giving you the rights. Or they may say, well, you got to pay me a bunch of extra money for that. So that's a kind of a practical issue to keep in mind. You may be prevented from exploiting certain rights in intellectual property that you thought you owned, right? So because if you do that, you're going to basically infringe on somebody else's rights. You want to make sure that you're not using intellectual property that you don't have all the rights to. If you don't own IP, you're not going to be able to enforce the rights against third parties. So somebody else is using, let's say, a trademark that you have. If you don't own all the rights to the trademark, then you're not going to be able to prevent them from infringing on their, basically for them using whatever that intellectual property is. So that's another reason, like an intellectual property is an asset of the company, right? So you want to make sure that you protect those assets as much as possible. Another example is if a founder leaves the company and they can set up a competing business. If they never assigned over their IP rights to the company, then there's nothing necessarily preventing them from actually using that IP. I actually had an example of this a year or two ago where I had a person come to me who had founded a company. It was her idea. She started working with a software developer, and they were going to be founders of the company. And they started working on the code, and it was all her ideas, and he was building the code. And then there was a falling out between the two of them, and he left. And so she ended up having to start over because he was the creator of all the code for the software. So he owned it all. She had no rights into the actual software. She had to basically start over, kind of get a new founder, and then make sure she had all the correct agreements in place. Investors and acquirers, I mentioned this briefly before, but essentially, if a potential investor or acquirer discovers that your company doesn't own the IP, it can have really severe consequences. And those can include basically a determination that your company is a lot more risky and less attractive than they actually thought it was. And they'll find this out when they do due diligence on the company. And they'll do that due diligence, and either they'll actually get in and look at the IP that you have, but they'll also look at all the agreements that you have, and they'll hire attorneys, basically attorneys like me, to go through all of your agreements to make sure that you have everything. And you'll have to make reps and warranties within a financing or an acquisition document that say that you own everything, right? So if you don't own it, then they basically may just lose their interest and walk away. So you may lose the deal and not get funded or not get acquired. There can be delays in the closing of the transaction if you're trying to resolve issues. Like if you have had independent contractors create IP and you don't have assignments of that IP, then you got to go get those, and that can really cause a lot of problems with getting the deal done. It increases the cost. It's way more expensive to handle IP ownership issues later on, especially if you're in connection with a financing or an acquisition. It'll a lot more hassle for you, a lot more cost with attorneys, and you may actually have to pay more money, right? Sometimes the investor or acquirer may lower the valuation. They may say, well, you're not worth as much as we thought you were because we thought you owned all your IP and had all these intellectual property assets, but you really don't. And so they may reduce the price or increase the escrow in connection with the risk that they're taking with the financing or the acquisition. In addition, you may find yourself as your company gets more successful, people will come out of the woodwork, right? And you can find yourself subject to a legal claim when you're going through a financing or an acquisition, and that can create problems too, right? I mean, no investor or acquirer is going to want to be involved in any kind of like litigation or legal dispute, and so that can create all different kinds of problems for you. It also can cause you to breach your reps and warranties in those agreements if you say that you own something that you don't. So how is ownership obtained? So the thing to make sure that you're doing, and you want to do this right from the start because it's a lot easier to do this when you're hiring people. Almost everybody that you're going to hire is going to be an at-will employee. You'll have some sort of offer letter, and then in connection with that, you'll have an agreement that you're going to get them to sign right when they first start. And so these agreements, these PIAs, proprietary information inventions agreement, have assignment clauses. And so they require the employees to sign over all the rights to intellectual property that they develop while they're working for the company. It actually requires them to devote full time to working for the company. And then those agreements also allow you to put some additional obligations on, highly skilled employees or officers of the company, where you can actually get them to agree to non-compete. Non-compete clauses are generally not enforceable against regular employees, but they can be enforceable against, key employees. If any intellectual property of the company is going to be created by a non-employee, then you're going to have a contract in place with those independent contractors that has an assignment, and then you're going to want them to assign it before they start creating anything. You do not want to have to go back later and get them to agree to assign things to you that they've already created. It can create problems in the formation of the agreement if you don't have proper consideration. Like, you can't use like past payment of somebody as a consideration of an assignment that happens later. And so you want to make sure that the contract is clear that while they're working for you and working on the project or whatever it is, that whatever they create is owned by you. Now that's the best rule. It may not be applicable in every case, because there may be some IP that they actually can't assign over for you for various reasons, and I'll talk about that in a second. And then creation by third parties. So this is, as opposed to kind of individual independent contractors, if you're doing business with other companies, you're going to want to make sure that those agreements, they're generally services agreements or things like that, they actually have provisions in them that talk about intellectual property creation and who owns it, and licenses and things like that. Again, make sure that with that all the IP that the founders have created is assigned over, and you usually do that at the very beginning when you're forming the company, and your attorneys are creating all the founding documents like your operating agreement and things like that. So let me talk a little bit about ownership versus control, right? So in the cases where intellectual property is being created and it can't be assigned over, then you have some alternatives, right? So a common example would be, let's say you hire a software developer and they have software that they've already developed that they're going to use in connection with what they're developing for you. So they're going to create some new code that would be a deliverable under the contract. You would want that assigned over to you, but as part of the deliverables, there may be pre-existing code. And so they may not be able to sign that over to you because they use it in connection with their business and their other clients that they may hire into. So what you want is a license that is essentially equivalent to ownership as much as possible, which is, if they need to maintain rights, would be a non-exclusive license, very broad, that essentially gives you all the rights to whatever that intellectual property is that you need to do whatever you want to, right? So, you can get exclusive licenses. In the situation I mentioned, probably not, because then if somebody gives an exclusive license to somebody, then they don't have the rights themselves to use it. So you may want to get a broad non-exclusive license. You may also want a broad license to things that that they have that they may just be using in connection with the IP that's being delivered and not necessarily part of it. So these are things that you're going to talk to your lawyer about to make sure that they help you figure out what's being created and what bucket it's going to fall into, to make sure that the language in the contract does what it's supposed to do, which is give you the rights that you need to run your business. Another category of IP that you have to pay attention to is third-party IP. So let's say you hire a developer, they're going to create some code, they have pre-existing code that they've already created, they're going to use that, but they also may want to use some open source that's going to be owned by a third party. And open source is actually just software that's owned by somebody else that's licensed under a particular type of agreement. So you're not going to be able to own that. You're going to want some sort of license to that. It could be non-open source. It could just be some sort of software that somebody else owns that you need to use in connection. The key is that you don't want to have somebody create intellectual property for you that, in order for you to use it as you intend, it's subject to other rights that you don't have, right? Because that creates a problem for you. You need to have all of the rights you need to have in order to be able to use that in connection with your business. So basically the solutions that I'm proposing are that, hire an attorney who specializes in business law for early stage companies, right? While generalists might seem like cost-effective alternative, there's a higher likelihood that a non-specialist will be missing something. And I was actually an expert witness in a lawsuit where a business attorney somewhere created an intellectual property agreement, like a developer agreement, and just said that the company would own the IP without having the magic words of assignment. And basically that attorney was committing malpractice, right? So you want to have people that do this all the time help you out so that they can make sure that you're covering all the bases, but they're doing it in a way that, let's say, your investors or your acquirers down the road will expect, right? There's a certain way that people will expect to see these things done, and somebody that has experience in that is going to be much more helpful than somebody who just does general business law or something. Use the following agreements all the time. For founders, you want technology assignment agreements. For every employee, including the founders, you're going to want proprietary information inventions agreements. When you're talking to people about your business and you're disclosing confidential information, you want to have them sign non-disclosure agreements in every case. Now, you're going to try to get them to sign it in every case. If some people won't assign it, and you'll find that in, let's say, venture capitalists, they will never sign non-disclosure agreements. Then you're going to have to be careful about what you disclose because you're going to be required down the road to basically make a representation in an agreement, whether it's a financing or an acquisition agreement, that everybody that you've disclosed your trade secrets or confidential information to is under some sort of agreement that creates a confidential relationship. So you'll hear murmurs, around where people will talk about how NDAs are useless. That's not true. So don't listen to those people, because you have to have NDAs in place if you're going to be disclosing trade secrets, because if you don't do that, then you're not protecting the trade secret and you can lose your trade secret protection. So, NDAs are common. People understand that they probably need to sign them. More than likely, the other side is going to be disclosing something to you they want kept confidential. So it's not a big deal. Use these, get a good form, put it in place, and use it all the time. Have independent contractor services agreements for all non-employees. I find this to be one of the things that gets messed up the most when companies are in their early stages. They do this in connection with, they're actually hiring people as employees, but they have them work as independent contractors for various reasons, right? There's pros and cons to doing that. The pros are that, yeah, you may not be paying employment taxes and things like that. The cons are that you may not own the IP if you don't have the proper agreement in place. Also, if you're actually treating somebody as an employee instead of an independent contractor, and there's very specific rules about what you need to do in order to show that somebody is an independent contractor, not an employee, you may have tax issues, you may have penalty issues, you may have to, if you hire somebody that really you're treating them as an employee and they get fired, they may be disgruntled, they make a claim with the Department of Labor that they actually are an employee, right? So there's all kinds of reasons that you should have proper independent contractor agreements in place with all non-employees. And then once you start selling your goods or services, you're going to want customer agreements that have appropriate intellectual property ownership and license provisions, right? So this is a way that you protect your IP. You may be somebody that, let's say, provides some services to somebody, and your customer will want you to assign to them intellectual property that may be created in connection with your provision of services to them. If that's your business, that's fine, but a lot of people, maybe you're just providing support or implementation services and you're not really creating any IP. And if you do, that's not really what they're paying you for. So they wouldn't own that intellectual property. And this may sound pretty obvious, but make sure you get your agreement signed. This happens all the time where you go back and you're trying to find out what's going on in a contract or whether somebody's breaching it or not. And you go back and find the original and you don't have a signed version of the contract. And so you don't know whether that's enforceable or not. So it's really easy to do. It sounds really dumb to say it, but make sure that you get your agreement signed. And I know I ran through this really quickly, so I know we have time, and I'm happy to take any questions that anybody has.
Ben, God bless you, man. This is amazing. I learned more about IP and probably have a little bit more anxiety than I had before you began the webinar, but because of the great points that you raised. So I guess, I was especially struck when you were giving the hypothetical of a founder who is working for obvious reasons, a startup, with independent contractors, right? And I think you used the hypothetical of hiring a CMO as a independent contractor. So do I understand correctly, and for our listeners and for those that will be sent this information in this webinar, then do I understand correctly, without assignment language, no matter what has been agreed to verbally, if the founder hires an independent contractor to serve as the CMO, the Chief Marketing Officer, any and all work that CMO does is the exclusive ownership, or that person has the exclusive ownership. Is that correct?
Yes, generally, right? So let me parse that out a little bit first. Like, if you're really hiring a chief marketing officer, is that person going to be an independent contractor or an employee, right? Because again, it doesn't matter what contract you have if you actually treat somebody as an employee, and most officers of a company are going to be employees. So you need to be careful about that, right? But yes, if they're really not employees of the company, then what they create for you will be owned by them, unless they have a written agreement that says that they assign it over to you. So this is, like I mentioned, it's not an uncommon problem, because people assume that if they hire somebody to create something for them and they pay them for the services, that means that they own whatever the results are. And that's not the case under law, right? So
so obvious, but Ben, this is huge. I can't imagine the number of companies, founders, either solopreneurs, solo founders, or co-founders that actually come to your office, sit down with you, and they are absolutely floored. Or is it just me that is surprised by the answer regarding assignment language that you just gave?
No, no. In fact, this is Jim. This is the main reason I decided to use this on this topic, right? To talk about this topic, because it's very important for founders to understand these kind of basic fundamental rules, and because they're really easy to follow, right? So if you don't follow them because you just don't know what the rules are, then it's easy to create problems for the company down the road. But um, um, yes, I would say, I don't know exactly. I mean, I'll talk to people about this right from the start, just because if you have these agreements in place and you have forms for them, it's really easy to get everything signed. It's so much harder to go back in time. In fact, I mean, I'm doing this right now. I have a client that formed the company 6 months ago before we started to help them, and they started doing a bunch of development work with non-employees, right? And now they have to go back and get agreements in place that essentially assign over all the rights to the previously created IP, and they're actually paying them some extra money to make sure that those agreements are enforceable down the road. But yeah, it happens all the time, and it's something that I feel pretty strongly about, but it's an easy fix as long as people know.
Oh my gosh. I mean, and to your point, I mean, it's human nature, I guess, with founders. I mean, I can maybe just speak for myself. I don't think I'm unusual. Perhaps we're working remotely. We don't have a face-to-face extensive relationship with the independent contractor, and we take people at their words. But obviously, you as an attorney, you cannot take anyone at their word at any time. If it's not written, it's not enforceable as a bottom line rule of thumb, correct?
Yeah, that's right. And let me just put it this way. It's funny because the problem is that both sides probably think that the company owns the IP without a written assignment, right? And so there's no nefarious intent on the side of the contractor, as far as they know. In fact, I don't want to overstate the risk either, right? It's not like, all independent contractors come out of the woodwork and start, suing their the companies that they've worked for.
Right.
But so it's more of just making sure that you lock up all the rights. Because it could become a problem later. But, I think most people assume that an independent contractor will assume that when he does work, he's assigning over all the rights. And so it's really, you may never have a problem, right? This happens all the time. Let me just put it this way. And if you have a company that, let's say you don't take any outside money, and nobody's ever going to be really doing due diligence on your company to determine whether you have obtained all the rights, you may never have a problem, right? You go on your merry way thinking that you have all the rights, and it's never a problem because the person that created it for you, they thought they gave you all the rights too. But we see it all the time when there's some certain transaction where people have to make reps and warranties about what they own. That's usually when it comes up. Or if there's some sort of dispute, like let's say you hire an independent contractor, and the most common thing is that the scope of work wasn't set enough where the provider of the service thought it was one thing and the receiver of the service thought it was another, right? So there's some dispute, and they basically go their separate ways. Well, if you have an agreement that talks about what you're going to build and you don't have an assignment provision in it, you may assume, but then the other side says, no, hold on a second. You don't own this stuff. I do. And then you're kind of in a tough situation.
No, you're screwed. You're right. Ben, I tell you, this is tremendous content, and that I'm sure some of our community members, not just those in Denver, but especially as it pertains to federal law versus, I think, the distinction that you made with something that is
the trade secrets. Yeah.
A best practice. No, is it what's state law?
Trade secrets are covered by state law.
There you go. Got it. And Ben, this is fantastic. If there's, if you were to just try, if you could give one piece of advice for all our members that are in the ideation mode, that haven't created the legal entity just yet, besides obviously, and you're too humble to say, besides calling you and KO Firm, what one piece of advice, if there's only one thing, one sentence that all founders would have to listen to, what would that be?
I would say make sure that you start early with your perfection of your IP ownership, right? Don't wait.
Awesome advice. Excellent. Ben, please share with our community. I know you've given it to us, but one more time, how can our members follow up with you personally?
You can contact me via email. My email address is boelsner@kofirm.com. I'm also on LinkedIn. You can contact me through there. I'm on Twitter. And you can go to our website, kofirm.com, and there's a people section there. And anybody that's listening to this, if you contact me directly, I'm happy to answer any questions. It's one of the things I like to do to try to give back to the community.
Ben, from a personal note, I can't thank you enough. I only wished I had met you, or we had met years ago. You would have saved me tens, if not many, many tens of thousands of dollars, but better late than never. Thank you very, very much, Ben. And we look forward to hearing you, seeing you in person, share some of these key deliverables and content at our upcoming ForgeN Now Summit. Shameless promotion, I know.
All right. Thanks, Jim.
Thank you.
Appreciate it. Okay. Bye.
Bye-bye.